Affidavit of Military Service. The Affidavit of Military Service is a 2-page mandatory document required in uncontested divorce cases to confirm whether either party is currently serving in the military. This information is critical because certain protections under federal law, such as the Servicemembers Civil Relief Act, apply to individuals on active duty. Steps to complete the affidavit. 1. Fill out the caption as usual. 2. If neither party is in the military, check box 2. 3. If one party is in the military, check box 1 and provide the required details, including the branch of military service, any additional information requested by the court. 4. After receiving your final divorce decree judgment, you must send a copy to the branch of service where your spouse is stationed, notifying them of the divorce. 5. Sign and date the form in front of a notary public. 6. Complete the non-lawyer section as usual. Affidavit of Corroborating Witness. This form is required in a Florida divorce case only if you, the petitioner, cannot provide proof that you have lived in Florida for at least 6 months before filing. Florida law mandates residency as a requirement for divorce jurisdiction. If you cannot provide documents proving your residency, such as a Florida driver's license, voter registration, or a lease agreement, you will need to use this form. Steps to complete the affidavit. 1. Find a witness who knows you and can confirm that you have lived in Florida for at least 6 months. The witness must have lived in Florida for more than 6 months and be able to verify your residency. Common choices include a friend, family member, or neighbor. 2. The witness will provide their information and complete the document. 3. The witness must date and sign the form in front of a notary public to make it official. 4. The witness is required to provide a copy of their Florida driver's license or another valid ID showing their residency. 5. Attach a copy of the witness's ID to this document before submitting it with your packet. Answer and waiver. The answer and waiver allows your spouse, the respondent, to formally respond to the divorce proceedings. By signing this document, the respondent acknowledges that they have received and reviewed all the documents you, the petitioner, filed with the court. Once these documents are provided to the respondent, you, as the petitioner, are not permitted to make changes to them. The waiver portion of the document means the respondent is waiving their right to be formally served with additional documents. They also agree not to contest the divorce, which helps streamline the process. Additionally, by signing this document, the respondent is requesting a copy of the finalized judgment once the court issues it. This means they don't have to appear at the final hearing if they choose not to. Ensure that the respondent reviews every document you are filing with the court, including the petition, supporting affidavits, any documents they are required to complete. Respondent's forms. The respondent will need to complete and notarize the following forms, which are listed in the document order list: financial affidavit, marital settlement agreement, notice of Social Security number, parenting plan if applicable. Once completed and notarized, the respondent will hand these forms back to you. Notice of Social Security number. The Notice of Social Security number form is a required document in divorce cases involving children. This form ensures the court has accurate information to assist with calculating child support and keeps that information confidential in the court file. Steps to complete the form. 1. Both parties must complete their own form, so you will be submitting 2 forms, one for the petitioner and one for the respondent. 2. Check box 2 to indicate the relevant situation. 3. List the names, birth dates, and Social Security numbers for each child born of the marriage. 4. Date and sign the form in front of a notary public. 5. Complete the non-lawyer section at the bottom of the document.